To come here today. I'm going to talk today as a political philosopher, not as a lawyer, though I am going to talk about human rights and even some institutional implications for a particular view of human rights that I'm going to discuss. And some of those implications will concern international law. Over the last few centuries, the dominant goal or value of the international order has been peace and stability. Since World War II, we've seen a steady movement towards including as a co-equal value with those justice, also as a value, virtue, or orientation towards the international order. There's a great deal of disagreement with respect to what global or international justice might mean. There are first, of course, skeptics, so-called realists in international relations theory, who think the idea is either descriptively or normatively problematic. And then even among non-skeptics, there's a significant amount of disagreement as to the content and nature of global or international justice. I'm going to cut through all of that. Let's just rule the skeptical positions out, set aside realism. We could talk about that in Q&A if you want. And I'm going to declare my allegiance straight away to a particular position within the non-skeptical views about global or international justice, what I call a moderate internationalist cosmopolitanism. Now, moderate internationalist cosmopolitans are folks like John Rawls, David Miller, Leif Wenar, Alan Buchanan, and myself, all of whom affirm the following commitments or positions among others. First, personhood is a basic or foundational moral status. Second, personhood carries with it self-authenticating valid moral claims. These claims impose duties on others, so that personhood is a moral status that carries with it self-authenticating claims, and those claims impose duties on others. These claims require a world within which basic human rights are fully secured for all persons, whatever those basic human rights turn out to be. This world, a world within which basic human rights are secured for all, is a world within which there are diverse, independent political communities. It is not a world within which there is a single world state, liberal, democratic, or otherwise. Global justice, then, is international justice. It is justice between independent political communities that fully satisfy basic human rights. And the principles of international justice would be those that could be affirmed by all such polities from their point of view as independent political communities. Now, this much out of the moderate internationalist cosmopolitanism is shared with all cosmopolitans, namely that basic human rights lie at the core of international or global justice. All cosmopolitans affirm that. The moderate cosmopolitan, or the moderate internationalist cosmopolitan, is distinctive with respect to his or her understanding of the state system and its relationship to global or international justice. Now, before going on and talking about the moderate international cosmopolitan's view of basic human rights, and that's what I want to focus on, let me say a few words about the nature of human rights generally, and then basic human rights more specifically, so we can be clear about what we're talking about. Human rights generally protect persons against substantial and recurring threats to fundamental interests. They do not protect persons against all threats to all interests. They protect persons against substantial and recurring threats to fundamental interests. They are deontic in nature, and so they function as trumps against evaluative or other sorts of teleological considerations in moral reasoning. That is, they trump considerations with respect to the good or with respect to particular sorts of goals we might be pursuing. They are weighty, quite weighty, as deontic considerations. Importantly, all human rights have a certain sort of structure to them, a triadic structure. There's always a right holder. The right holder is always a natural human person. There's always a scope. The scope is the object or content of the claim, what you have a right to. And there's always a determinate addressee. That is, there's always somebody to whom the right is addressed and thus imposes a duty. Most, I think probably all human rights, certainly most, are claim rights. And if we follow the Hofeldian analysis, claim rights always entail duties, and there's a determinate addressee. Now, the addressees may, in fact, be multiple, but they'll be lined up in a sort of serial order. So there's a primary addressee, and then in default of the primary addressee being able to satisfy the right in question, there will be a backup addressee and then potentially further backups. The duties that these addressees are subject to by virtue of the rights of others will themselves be complex. The duties will always involve a duty not to deprive people of their rights, but they will also include a duty to secure institutions or bring about institutions or support institutions that protect people in their rights and that aid people whose rights have been deprived. And so the nest of duties that all addressees are subject to are rather complex and multifaceted and will certainly have institutional implications. Human rights of any sort are, of course, universal. They apply to all natural human persons. They constitute a morality of the floor rather than the ceiling. That is, they're kind of mandatory minimum, and they're political and institutional in nature. Now, if we take as a subset of human rights the idea of basic human rights, we want to add the following sets of conditions. Basic human rights are those that apply or normatively bind independent of any voluntary act by others. That is, their normativity is not consent-based. These are rights, the normativity of which depends on moral arguments, moral reasons, independent of any voluntary undertaking. So you might imagine some rights that just come to be by virtue of treaty, right? And then those rights that, even if there was no treaty on them, would still be, in some sense, basic human rights. Basic human rights are also, therefore, the morally necessary core of any international public reason. That is, any system of international public reason giving between polities with respect to foreign policy and international relation will, of necessity, contain basic human rights as part of its core. And we would expect, in the ideal, all well-ordered polities to affirm these basic human rights. Basic human rights then also have a sort of distinctive function, different from human rights more generally, which include those that might just arise through treaty or voluntary undertaking or customary practice over time. Basic human rights function as a necessary condition for the recognition of polities within the international system. That is, they function as a necessary condition for the full standing or full membership of a political community in the international order. And lastly, basic human rights would have to be aimed at the most fundamental of interests that might be threatened by substantial and recurring threats that could be protected by a basic right. And these interests would include the following: the interest in life itself, the interest in being able to lead the life that you have, and then the interest in avoiding certain sorts of great evils that render a life not worth living, potentially not worth living. Torture, slavery, things of that sort. Great systematic unfairnesses, and so on. Now, what I'm concerned with is identifying a list of basic human rights from within the perspective of moderate internationalist cosmopolitanism, and in particular providing a philosophical foundation for that list and then thinking about the institutional implications of that list. And that's what I want to talk about today. Now, one way to settle on the list that I don't want to follow would be to just consider what would be involved in securing a minimally worthwhile life or a minimally valuable life for any human being. Now, I concede that any list of basic human rights that we arrive at should strike us as necessary and sufficient to some notion of a minimally worthwhile life. I don't think that an investigation into the content of a minimally worthwhile life directly is going to yield us a philosophically sound account of what the basic human rights would be. That is, would answer the list question in an effective way. So what I want to do is pursue a different tack. I want to think from the natural duty of justice. So let me talk a little bit about the natural duty of justice, and then I will connect that up with the moderate internationalist cosmopolitan view about basic human rights. Of course, we start with the idea that human persons have a sort of basic moral status, a dignity, a worth that ought to be respected, that grounds rights, imposes duties on others, and so on. Now, this status of persons, I think, is inextricably bound up with membership in a polity, membership in a political community. We can think, if we like, about Aristotle's view that the human person does not, in fact, exist in a fully developed form apart from political membership. Now, there's many reasons for this, plausible reasons. I don't want to make the case for this view at great length, but let's just rehearse a few of the reasons. The first is that the capacity of human persons to engage in just relations with others can only fully be realized in the relations given by a political community, something that exceeds the scope of the family or clan, that puts members who are not related to one another in a system of rule-governed interaction by which they can assess their claims against one another. And it's only within that context that one can find one's status as a person capable of such just relations with others, publicly affirmed by others, publicly affirmed by the institutional environment within which you find yourself. And it's a feature of natural human persons that our self-understanding or status as persons is partly delivered to us by the social world that we find ourselves in. Right? We find that status mirrored back at us and we internalize it. Right? And so one needs to exist within a social circumstance within which just relations are possible and within which one's sense of justice can be exercised. That is, within which one can assess whether or not one is doing what one ought to in light of just relations with others. Now, the kind of polity that I have in mind here that constitutes a condition for personhood, that would be the thing that you ought to be a member of, is quite generic. We're talking about a rule-governed system of cooperation. And the word cooperation here is crucial. We'll talk about the difference between cooperation and coordination, for example. A rule-governed system of cooperation aimed at mutual advantage, however understood, at least minimally the common good, right? So that all parties are advantaged by it. And the rule-governed nature here has to be public rules, not secret rules. Rules that are known by all, that serve as public criteria for one's conduct within the system. And so we have to have a system of cooperation that's governed by a conception of justice. The conception of justice is given its content by the public system of rules that provide metrics for assessing claims persons have against one another within this cooperative activity. Now, membership in such a social world is not just a means to the good of individuals. It is a constitutive ingredient of the good of individuals as well. It is not just a means to our good, it is part of our good, right? It is an end in itself. And in this sense, we might say that all human persons have a claim to membership in some such political community. Now, let me talk now about the natural duty of justice. The natural duty of justice is that duty that each of us has to comply with, or at least accord prima facie moral status to the rules of the cooperative system that we find ourselves within. That is, it's the natural duty we have to do as justice requires. Now, of course, nobody believes that any cooperative system that they find themselves in will be thoroughly just or fully just. In fact, that's part of what membership delivers to us, is the opportunity to exercise our sense of justice by criticizing the institutional world that we find ourselves part of, and that's part of our full realization and great good. So the natural duty of justice is not just a duty to recognize the prima facie moral force of the rules that you find yourself subject to, but also to subject them to criticism and to aim at their reform. Right? In fact, sometimes to disobey them for the sake of their improvement, as we do when we engage in civil disobedience. And the natural duty of justice is also a duty to bring about such institutions, publicly rule-governed systems of cooperation, where they do not yet exist as between individuals who are regularly interacting. Right? Individuals who are regularly interacting, even if motivated by moral concerns and highly intelligent, will inevitably disagree over the demands of right or justice as between them, and will need some public criteria to settle those disagreements. And it's only by virtue of bringing about a publicly rule-governed system of interaction that they can secure that interest. So the natural duty of justice has these features requiring us to comply with, at least prima facie comply with, the rules that we find ourselves subject to perfect them, to reform them over time, and where they do not exist among people who are regularly interacting and find themselves disagreeing over matters of what is morally required to create them. Now, an interesting thing about the natural duty of justice, if you just think about those components, is that it has a special effect as soon as one crosses the threshold and finds oneself within a publicly rule-governed system of cooperation. Because as soon as you find yourself part of a publicly rule-governed system of cooperation aimed at the common good, you have prima facie moral obligations that you did not previously have. That is, you have prima facie moral obligations to obey the rules of that polity, to do justice within that system. Now, those are prima facie, they're defeasible, they can be overruled if necessary to secure more perfect justice within the system, etc. But the members of a system of cooperation are bound together now in a common moral project that outsiders are not part of. Right? Outsiders are not part. Outsiders do not. I have no prima facie moral obligation to obey the laws of Spain or France. I do have a prima facie moral obligation to obey the laws of the United States, right? Assuming that it's a publicly rule-governed system of cooperation, which I think, in fact, it is. Okay. Now, if outsiders are to respect the status of insiders as persons possessed of a natural duty of justice, they will have to respect that asymmetric moral relation. Namely, that insiders are bound together in a common moral project that outsiders are not part of. And if they're to respect the capacity of insiders to exercise their sense of justice, they ought not displace the ability of insiders to assess for themselves how to weigh the prima facie moral obligation to comply over and against the obligation to perfect and reform, maybe even to engage in civil disobedience, and so on. right? Assuming that the conditions of rule-governed social cooperation are in fact realized, outsiders respect insiders by allowing them a degree of autonomy or independence within their system of cooperation. It's theirs, in some sense, to perfect and reform on their own. Now, that doesn't mean outsiders can't engage in dialogue, can't make suggestions, but the use of force, soft or hard, to displace the space within which insiders exercise their own sense of justice is an affront to the status of insiders as persons with a sense of justice and a natural duty of justice. Now, as I'll suggest in time, I think this natural duty of justice has implications not, and I've already intimated this to some extent, not just for domestic relations, but for international relations as well. Insiders, acting on their sense of justice, will of course be concerned to perfect the justice of their own polity over time. And the justice of their own polity over time will be, no doubt, bound up with international conditions. Obviously, international peace and stability bears on the possibility of sustaining and perfecting the justice of one's own polity. Difficult to do if one is constantly being aggressed against or having to aggress against others and so on, right? So peace and stability, traditional values of the international order, can be tied here to the natural duty of justice. But of course, it's also necessary that polities engage in just relations with other polities when they do. That's part of perfecting a domestic theory of justice, right, or a domestic system of justice. And so the natural duty of justice will lead insiders to want to perfect the foreign policy of their own polity. Right, to perfect the foreign policy of their own polity as a way of ensuring and perfecting the justice, viability of their own polity over time. Now, what does all this mean for the list question with respect to basic human rights? Well, I think what we're asking is, what are those conditions necessary and sufficient to a publicly rule-governed system of cooperation aimed at the common good, such that the natural duty of justice binds those members or participants in a common moral project that outsiders must, in fact, respect as an independent political community. Now, I think we can answer this by thinking a little bit about how H.L.A. Hart talked about legal obligations, simply qua legal obligations, not qua prima facie moral obligation to obey the law, and then ask, what would we have to add to Hart's account of just legal obligation qua legal obligation to make it plausible to think that individuals have a prima facie moral obligation to obey their really existing legal obligations, just qua legal obligation. Okay? So here's what Hart says about the nature of legal obligations simply qua legal obligations. Right? They concern the nature of publicly rule-governed systems of cooperation, or at least publicly rule-governed systems of certain sorts of interaction. First, officials must have internalized and must be compliant with what Hart called a rule of recognition. And the rule of recognition here just refers to foundational criteria of legal validity, right, that have to be internalized by officials, and officials must remain faithful to those criteria in their activities, criticizing one another for departures and so on. This secures the rule-governed nature of the system. Right? Officials are following rules. They are not, in fact, merely exercising their will. Secondly, for legal obligations to exist, there must be, or at least for us to talk about their existence in a sensible way, there must be relatively widespread and effective compliance. Right? In the absence of relatively widespread and effective compliance, it wouldn't make sense to talk much about legal obligations at all. Third, there must be fidelity to formal equality, or what Hart called administrative justice. Right? A core feature, but not the total, of the rule of law. Okay? So like cases are treated alike within whatever system of rules officials are enforcing. Now that's really all Hart thought as a legal positivist was essential to the existence of a legal system and hence the existence of legal obligations, qua legal obligations. He's a positivist. Hart also went on to say, though, that if we were to, as a descriptive matter of fact, imagine a legal system enduring for any length of time, we would have to add a further condition, namely that the content of the legal system secured what he called the minimum necessary natural law content for a wide enough segment of the ruled population such that they found it in their interest to remain faithful to the system, to support it, to not revolt, etc. Now, Hart didn't think that this minimum necessary natural law content, protecting people's basic physical security and so on, had to be secured for everyone. That might be morally desirable, but it wasn't empirically necessary to the enduring nature of a legal system. A slaveholding system might exist for some significant period of time, but you had to provide this content for a significant enough segment of the population, or a powerful enough one for them to secure the stability of the system longer term. Now, we can build from that to start thinking about what further would have to be added for everybody to have within this system a prima facie moral obligation to obey the laws of their polity. And the first and most obvious thing is that this minimum necessary natural law content, protecting physical security, enforcing certain sorts of contracts and so on, would have to be extended to everyone. Right? You don't have a system of cooperation if that minimum content isn't extended universally to everyone. The second thing is that the conception of justice that is reflected by the rule of recognition that, when tied to the rule of recognition that officials enforce, must itself aim at the common good. It must at least be a common good conception of justice. Justice cannot be simply the interests of the ruling class or what have you. There has to be some plausible story that ties justice to the common good. And then lastly and importantly, and this is something that Hart leaves out. On Hart's view, it's important that rulers, officials, have their reasons for exercising authority, right, to ensure that the exercise of their authority is rule-governed and not mere might or force. But it's not essential that rulers have reasons that could be plausibly offered to those that they rule. In fact, it's conceivable on Hart's view that you have a legal system within which rulers just act together as a group, a sort of cabal following all their own reasons, and citizens either have no idea what those reasons are or might reject them, etc. Okay? Now there we wouldn't have a public rule-governed system of cooperation. So what's the last condition we need? We need some sort of reciprocal reason-giving activity between ruler and ruled. Officials must not just have their reasons, but they must be prepared to give their reasons in good faith to those that they rule. And that reason-giving activity is reciprocal only if those who are subject to those reasons can then call them into question, can interrogate them, can put pressure on them, and so on. Right? It doesn't mean that they get to themselves become officials. It does mean, just like the child doesn't get to become the parent, it does mean that there's a reciprocal activity of reason giving going on there. Now, when those conditions are satisfied, it looks like we have a publicly rule-governed system of cooperation within which the natural duty of justice is plausibly triggered, giving rise to prima facie moral obligations, binding the participants together in a common moral project that outsiders are not part of, and that outsiders ought to respect. Now, what's been left off, and if you ask me to sort of summarize the list here, I think Rawls comes pretty close to getting it right. Read Articles 3 through 18 of the Universal Declaration of Human Rights. 3 through 18 roughly covers it. You'd want to add the Convention on Apartheid and Genocide, but those are also obviously implied by Articles 3 through 18. Okay? Now, what's left off? Well, 4 classes of rights that have proved especially controversial and that more robust non-internationalist cosmopolitans affirm, but that the moderate internationalist cosmopolitan relegates to a separate status, okay? Treating them as human rights to be realized through treaty making, voluntary acquiescence, customary practice over time. That's how they become part of positive international law, not as the morally necessary foundation of any sort of legitimate positive international law. And the four classes of rights here, the rights would fall under four classes. First, non-discrimination rights. There's nothing in the account of a rule-governed system of cooperation within which the natural duty of justice is triggered to suggest that there cannot be entrenched social distinctions that the law, in fact, tracks. Okay? Now, those entrenched distinctions have to be compatible with extending the minimum natural law content to all members. They can't be distinctions that leave people's physical security at risk and so on. But there may be forms of gender hierarchy or ethnic hierarchy or religious hierarchy that are nevertheless permissible within a system of rule-governed cooperation. That's not to say the system is just. It's just that it's just enough that its members become bound together in a common project. The second set of rights would concern the full range of liberal liberties. Obviously, part of the minimum necessary natural law content, part of what's necessary to any system of fair cooperation, will be, not fair cooperation, rule-governed cooperation. Importantly, I don't want to use that word fair there. Rule-governed cooperation will be that people have a right to liberty of conscience and thought. They can't be physically coerced into confessing beliefs. They have some ability to exercise their own religious practices and so on. But the full range of liberal liberty rights, to produce and consume pornography, right, surely are not necessary ingredients to a rule-governed system of cooperation. So we'll have debates over those rights. Political participation rights. While it's necessary that there be reciprocity of reason giving between ruler and ruled in a system of cooperation that triggers the natural duty of justice, it's not necessary that there be anything like democratic political participation rights. There need to be rights of dissent, rights to be heard, rights to be free from political imprisonment, and so on. But there need not be democracy. Which is why I said UDHR 3 through 18 and left 21 off the list. It's debatable whether 21 actually requires democracy or not, but nevertheless, 21 does point towards a rather robust conception of political participation rights. And lastly, what we might think of as welfare rights. Rights to public health system of a certain sort and the like. Social security, what have you. All of the rights that fall under these four headings may be necessary to a fully just society. They're certainly necessary, on my view, to a fully just society, the members of which think of themselves as its free and equal co-authors. That is, they're necessary to a just liberal democracy. But they seem to me not necessary to social cooperation that's rule-governed, aimed at the common good, and sufficient to trigger the natural duty of justice, binding participants in a shared common project that outsiders ought to respect. So what's required? I think if we take if you're just looking for a thumbnail label for what's required by basic human rights, just stick with constitutional republic. Res publica, aimed at the common good, constitutional, subject to public rules, officials have internalized, follow themselves, and so on. Constitutional republic. Lots of non-liberal, non-democratic forms of constitutional republics. Now, there are three ways then in which basic human rights might not be secured. And it's important to distinguish between these three ways in which basic human rights might not be secured. Consider the first case. There is no reciprocity of reason giving between rulers and ruled. Rulers, in fact, secure the minimum necessary natural law content for all those that they rule, So those that are ruled enjoy the content of basic human rights, but they do not enjoy them as a matter of right. Right? They enjoy them because they are the lucky beneficiaries of, let's say, a benevolent absolutist ruler. Okay? Now, that's a circumstance where we have a failure of basic human rights, and the international community has no reason, principled reason, to recognize, respect, or accord full standing to that polity. It's not a system of cooperation, the members of which are bound together in a common moral project. It's a system of coordination, no matter how benevolent. And the human rights failure there is neither justified nor probably excused. Nevertheless, the international community probably ought to take a certain sort of begrudgingly tolerant stance towards such a polity, since the content of basic human rights is secured for all, even though not as a matter of right. There would be little reason for coercive intervention, and if in fact members chose to defend their system and chose without the content of their basic rights being put at issue, that is, the ruler isn't threatening them with starvation or harms to their physical security, we would probably want to say benevolent absolutisms have a right of self-defense. Right? They have a right of self-defense provided the members voluntarily wish to defend, subject to the condition that the content of their basic rights is not put at risk. Right? So if you want to defend that sort of a system, it's your right to defend. So the international community takes a sort of begrudgingly tolerant stance towards this sort of a failure of basic human rights. And what we hope is over time that people will assert their claims for political participation, and that will eventually be honored. A second sort of case, however, is different from the benevolent absolutism. In a second sort of case, what we confront are polities within which the material or cultural conditions simply prevent the emergence of a publicly rule-governed system of cooperation within which there are officials who have a certain sort of authority that others have a prima facie moral obligation to obey. Here, the content of basic human rights just isn't enjoyed, whether as a matter of right or not. There's mass starvation. There's a failure of the rule of law because the institutional requirements of the rule of law aren't on the horizon, and so on. Again, here, noncompliance can't be justified, but here, if the material conditions are in fact the obstacle to noncompliance, noncompliance can be excused. Everybody knows the distinction between justification and excuse. Right? And so there are no rulers who are unjustifiably violating human rights, but there's an excused noncompliance. And here, backup addressees for basic human rights are called to perform their obligations. Right? Others have an obligation to come to the aid of those who find themselves in such a circumstance, unable to fulfill their own natural duty of justice by constituting a civil order subject to public criteria of justice and so on, come to their aid and perform their duties by way of providing material and other sorts of assistance. A third sort of failure, and the one that we're most familiar with, you might call as Rawls does, the outlaw state. Here, the material conditions for a system of publicly rule-governed cooperation within which the natural duty of justice is triggered, those material and cultural conditions are in fact present, and in fact there is a de facto claimant of political authority. That is, there are officials who are able effectively to secure their will. But these officials violate basic human rights, right? Either of the members of their own polity or perhaps of outsiders by unjustly aggressing on other sorts of well-ordered polities. That is, they use the authority that they claim in a way that is inconsistent with the necessary moral conditions of its legitimacy, right? Both in the domestic and in the international perspectives. They use that authority in ways that are inconsistent with what would morally legitimate it. Here, noncompliance is neither justified nor excused, and it cannot even be begrudgingly tolerated. Outlaw states have no right of self-defense. There's nothing that, unlike benevolent absolutisms, the content of human rights are not even secured. And those who are on the outside have no obligation to respect an independent political community, and in fact have positive obligations to take affirmative steps to bring an end to that situation. Same sorts of basis that would ground their obligations of aid. Now, if we think about this last sort of case, I think we can see a theoretical basis for what in international law is now being discussed as erga omnes obligations. Erga omnes obligations are obligations that polities owe to the international community generally rather than to any particular state. Okay? And erga omnes obligations are obligations that are prime candidates for international criminal liability. Right? Crimes against humanity, unjust aggression, and so forth. And here we can see that because the morally necessary core of any system of international relations and law that is acceptable involves an idea of political authority aimed at securing a social world that triggers the natural duty of justice, the purposeful, systematic, intentional use of political authority for contrary purposes, which is what we're talking about when we're talking about genocide, crimes against humanity, serious unjust aggression, and so on, constitutes an affront to the entire international community and a plausible basis for international criminal liability. And there's therefore a theoretical foundation for what looks to many like an accident about the jurisdiction of the ICC, which is limited to crimes against humanity, war crimes, and so on. It looks like we may, in fact, be able to provide a philosophical foundation for that particular limitation that to many just looks like an accident of what we could achieve through bargaining. Now, I want to finish by specifying now 4 human rights agendas and then saying a word about some institutional implications. 4 human rights agendas. We need to pursue them all, but they're distinct. The first involves securing for all persons, natural persons on the planet, membership in a well-ordered political community within which the natural duty of justice is alive. I've given you my account of what the basic human rights that are necessary and sufficient to such membership are. A corollary of this agenda, and we'll talk about this under institutional implications, is limiting recognition or full standing in the international system to those polities that meet that condition. That's the first agenda. The second agenda involves dealing with the 3 classes of noncompliance that I discussed, each of which has a slightly different moral valence and requires a slightly different sort of exercise of our natural duty of justice as backup addressees to the claims of those who have their rights violated. That's the second human rights agenda. Everything from humanitarian intervention to economic sanctions to simple non-recognition for benevolent absolutisms falls under this heading. The third agenda involves human rights as an object of international politics. There is no reason to think that we ought to limit ourselves within international law to the list of basic human rights that I've mentioned. The list of basic human rights constitutes the morally necessary rights within any legitimate system of international law that must be secured. But well-ordered polities are free to and ought to voluntarily agree to take on more. And the international politics of human rights ought to be aimed at brokering such agreements, likely first on the regional scale and then expanding out from there, or maybe if not regional, by virtue of certain sorts of shared interests. You might see Islamic pacts with respect to human rights and so on, and eventually looking to aim at a more robust global order as a matter of positive international law. And then lastly, the last agenda, ensuring something like what the ICC is aimed at, namely criminal liability for those who systematically turn political authority to its contrary ends. This is a way of the international community affirming its core moral foundation. Those are 4 separate agendas. It would help considerably if human rights theorists and activists would be clear about where their particular activity fell on that list. Okay. Now, institutional implications. Just a few words here. Let's reject skepticism about the very nature of international law, although there's some recent debate engendered by Eric Posner and others about that, but let's set that to the side. Surely the development of international law is a crucial implication of the conception of human rights that I've suggested here, for at least the following reasons. The most obvious, of course, is that international law is going to play a huge instrumental role in securing effective compliance with human rights. But there's 3 other roles that international law plays that are also crucially important. First, the rights that are basic human rights that I specified are fairly abstract and are going to require specification within the international system and some adjudication with respect to whether or not particular concretizations of those rights are in fact adequate. International law can play a crucial role both in specifying those rights more concretely for particular contexts and adjudicating compliance with them. International law brings a special epistemic benefit to that project because as currently constructed, it involves multiple perspectives being brought to bear on particular sorts of questions as well as a great deal of expertise. And by virtue of those epistemic advantages, international law can play a 4th role, which is to legitimate the norms that are in fact being imposed. International law is also going to have to more fully embrace the idea that justice is among its primary aims rather than just peace and security. In fact, basic human rights is the core of justice within international law. And what that means is that Austinian and Hobbesian and 19th century Westphalian ideas of sovereignty are gone. Sovereignty is always conditional upon meeting, that is, de jure sovereignty are always conditional upon meeting certain sorts of obligations. This also means that consent cannot be the sole basis of legitimacy within international law or international institutions, a view that still prevails in many quarters. Now that raises a question about whether democracy or democratization is a necessary ingredient in legitimacy or ingredient of legitimacy in the international arena. I might say a word about that here at the end. I don't think so is the short answer, and I'll say why, but in any case, consent by itself is not the sole basis of legitimacy. Finally, the international legal system ought to accord, at least in certain contexts, standing to natural human persons. Presently, the international legal system is overwhelmingly oriented towards according only states standing. It ought to be according individual persons standing. That is in part a way of fulfilling its obligation as a backup addressee. Every natural human person is entitled to standing within their own polity. Right? And absent that, they ought to have standing in the international legal system, at least as a matter of backup addressees. This is what the ICC effectively secures. Now, another institutional implication here concerns what Alan Buchanan calls recognitional legitimacy. The status quo in the international system is a slight modification of the Montevideo Treaty regarding the status of states. The Montevideo Treaty says that if you can de facto claim control of a territory, you got a state, right? Roughly. There's a few criteria, but it comes down to a list of descriptive criteria, right? No normative criteria at all. As a matter of practice, we have evolved into a situation that adds the following descriptive criteria, namely some other states must recognize you, right? So you're not really a state with standing in the international system until you've satisfied the descriptive criteria of the Montevideo Treaty and some other states have recognized you. Why it's so important that Kosovo be recognized by the EU and the US and so on, right? But what we need is to move beyond mere descriptive criteria of recognitional status within the international order and to include the moral criteria of basic human rights. And so what we should have been asking with respect to Kosovo is for at least emphasizing that we had was some reliable evidence for the security of basic human rights. Now, this has crucial implications for a number of areas. Treaty making. Only polities that have standing within the international legal system should be able to enter binding treaties within the international legal system. Warlords who control territory by sheer force don't have the ability to enter into treaties. And it just follows, hop, skip, and a jump. They don't have the ability to borrow within the international monetary system. Nor do they have the ability to sell the national assets and resources of the territory that they control. And just suppose that it turned out that you couldn't sell the oil or the diamonds that lied beneath the soil that you had effectively seized through force. And all it would require would be the US or the UK in a domestic court to deny those transactions, right? Assuming that we don't have a bona fide purchaser for value because people are on notice. Most of the purchasers, at least initial purchasers of these resources, are on notice of who they're dealing with. They know that they're receiving stolen property, right? They're not bona fide purchasers, good faith bona fide purchasers for value, right? All it would take would be a major domestic court enforcing that with respect to some significant natural resources to break a huge incentive for warlords in burdened societies to govern in the way that they do. And this means also that international trade instruments must reflect basic human rights norms, and that in fact multinational corporations must take heed. Now, if we think about human rights compliance, the most significant implication concerns a shift from military interventions and throwing bags of rice to institutional development. In the past, during the Cold War, the most common sorts of human rights violations occurred in large, well-developed, well-armed states. Whereas a pragmatic matter, forgetting principle, the most one could hope for was jawboning. Right? Reporting, putting a lot of verbal pressure on states. Today, the most pressing problems are in failed states, ruled by warlords and the like. And here, not just the opportunity, but the obligation for institutional development is, in fact, crucial. And securing basic human rights ought to play a foundational role there. Things like the Tobin tax or POGA's proposed global resource dividend might play an equitable role, perhaps, although there's debates about the empirical conditions under which this would be true, might play an equitable role in raising the international funds to support these development efforts. but they wouldn't play on the moderate internationalist cosmopolitan view any further goal in redistributing global wealth. I think since I've talked this long, let me stop rather than saying anything about the non-necessity of democratization within the international order as an institutional implication. Let me just leave it at that. That's enough by way of institutional implications for the global order to at least get a conversation going. So I'll pause there.
Thank you. So we've got some time for questions.
Yes, sir.
John Wayman. You had a slight hiccup and said the word fair.
Yeah.
You described the communities that you were focusing on as rule-governed, publicly rule-governed systems of cooperation for mutual benefit.
Yeah.
Rawls makes a good point of them being fair systems of cooperation. So why are you avoiding the word fair?
Rawls makes the requirement of fairness an ingredient in a conception of justice for liberal democratic polities. He does not make the idea of fair cooperation an ingredient in the idea of a polity that has a rightful claim to full standing or recognition and respect in the international order. And on my view, those are just those polities where the natural duty of justice is triggered such that outsiders have an asymmetric relationship to insiders. And one reason why he does that is that it's not at all together clear that the idea of fairness could do any work in systems of cooperation that are organized on terms quite different from those we find in well-developed liberal democracies. In well-developed liberal democracies, a signal feature of the political structure is that individual members regard their relationship to the polity as fully unmediated by any other identifications, memberships, commitments, etc. That is, my claim on the polity is direct. Citizenship status, claim on the polity, right? And citizenship status is distributed to all equally, symmetrically, and so on. Okay? Now, in that context, we can give quite determinate content to what fair cooperation would look like. Fair cooperation would be cooperation that would be acceptable to members who regard their relationship to the system of cooperation as unmediated by any other group memberships or identifications and as symmetrically distributed amongst all of them. That is, they're all equal citizens, right? And you do an original position argument or some such thing to work out the content. But now suppose you have, and this is Rawls's paradigmatic example, the decent consultation hierarchy, right? Whose social form is associationist in Hegel's sense. All this means is that natural human persons regard their relationship to the polity that they are a part of and that is a constitutive ingredient in their good and all the rest as mediated by antecedent social identifications or memberships. That is, I'm a member of the polity as a Jew. I'm a member of the polity as a member of this clan. I'm a member of the polity as part of this ethnic group, right? Now, one of the things Rawls wants to drive home is that we cannot presuppose in advance that such a system of social cooperation, the natural human persons of which regard their publicly rule-governed system, right, as mediated by these other sorts of identifications and commitments, as illegitimate, right? There's no reason to suppose that the natural duty of justice might not be alive there. Now, the question that would then be, what would it mean to talk about fair cooperation in that context, right? You might be able to talk about it, but whatever its content would be, it would look quite different than what fairness looks like in the liberal democratic context, right? And Rawls just brackets the term fairness altogether there. What he's concerned with is that there be a certain kind of social cooperation such that the natural duty of justice is alive. Right? That's the first requirement. That gets you standing. Now, once you get to the point where members regard themselves as, and Rawls, I think, firmly believes that everybody, in some sense, ought to, he hopes that everybody will get to the point that members regard their relationship to their polity as unmediated by these other sorts of commitments, then we have a clear way of talking about fairness. So that's my hiccup. And I think textually, Rawls doesn't describe non-liberal, non-democratic polities that deserve recognition and respect in the international order, so-called decent polities. He does not describe them as a fair system of cooperation. He describes them as genuine systems of social cooperation. Yeah.
Easily imagine interference causing more human
Yes, yeah, right. So the first thing that we should be clear about is that when I say either you are permitted or, in grave cases, perhaps obligated to act, the action here, what fills in that black box called action, is quite open-ended. And will involve a moral accounting, as well as, and this is part of any plausible moral accounting, a sort of practical feasibility assessment. Okay? So obviously, if one was to do more harm to basic human rights through a certain course of action that might in principle be available than some other course, then one ought not take the former. Right? And if there were, in some circumstance, let's say, no path forward that was acceptable in terms of its own moral costs for vindicating one's natural duty of justice and coming to the aid of those who are systematically abused by a brutal dictator and what have you. If there's no morally acceptable way forward, then there's no morally acceptable way forward. That's a great moral tragedy if that were to occur. I doubt that it occurs very often, but if at all. But the clear truth here is that there's no suggestion that even a moral obligation to act entails a moral obligation to perform any act aimed at the right target. Right? One is obligated, in fact, to engage in the relevant moral accounting. Okay? And this is, in fact, a feature of human rights and institutional analysis that's way too often overlooked. And there's at least three different ways in which we need to talk about moral accountings here, and I'll just mention all three. The first, as soon as you're talking about human rights at the very least, whether they're just human rights that arise through treaty or whether they're the more foundational basic human rights that are morally necessary to any acceptable international order, human rights are meant to provide compelling normative direction. Right? That's what a right does. It's a weighty sort of deontic consideration that provides compelling normative direction. To do that work, right, we have to know in advance that the duties that the right imposes on others are themselves morally acceptable. A right that imposes duties, the costs of which are moral, that is, they're unfair duties and the like, right, is an implausible candidate for a human right because it cannot provide the kind of deontic normative direction because there's moral considerations likely to be deontic that are going to be pointing in the other direction. So we need to engage in that kind of moral accounting straight away. We also need to think at the level of institutions, right? When we are building institutions, even at the ideal level, that secure human rights, about how institutions and I hate this word, although you've used it a couple times, and I was going to make a joke over lunch or something, incentivize. I hate that word. But in any case, I'll use it. How institutions incentivize certain sorts of conduct, right? That's a crucial part of any moral accounting for human rights as well. Remember, human rights are political and institutional, whether they're treaty-based or based in the moral foundations of human personhood and the natural duty of justice and so on. And what looks plausible in an individual case will often be quite implausible when cast as an institutional norm, right? This happens all the time, for example, in bioethics. You know, you have some compelling intuition about a particular case, and then you imagine institutionalizing that norm, given, you know, the hospital setting and doctors and professional licensure and all the rest, and investment in research and what have you. And all of a sudden, the norm looks wildly implausible morally in that latter context. So we need a moral accounting of how these things function at the institutional level. And then thirdly, we need a moral accounting as we move from our non-ideal world, within which not even recognition of legitimacy and basic human rights and so on are fully secured, to the ideal that we're aiming at, right? And it's not the case that every path from here to there is morally acceptable, right? Not every path from here to there is morally acceptable. Only a handful of paths may be morally acceptable. And so as we move from the non-ideal world to the ideal world, the first two sorts of accountings are accountings that just happen as a matter of ideal theory. But as we move from the non-ideal world to the ideal world, we also have to engage in this moral accounting. And that's what you're pointing to, right? As soon as we're thinking about how to deal with outlaw states, right, we're thinking about, okay, in the non-ideal world, what are the morally acceptable paths forward? Recognizing that we have an obligation to act doesn't tell us which particular action is morally acceptable, and it is, in fact, possible, I think, in the empirical world that there would be no morally acceptable path forward. We have no a priori, unless you're a theist, you know, who rejects all these sorts of things, thinks the moral world is ordered such that this would never happen. But I have no a priori reason to believe that there are not, in fact, possible moral tragedies. Where we simply have no morally acceptable way to fulfill our moral obligations. I hope that doesn't happen.
What work does the qualification natural do in the natural duty of justice, and how is this related to the natural human person?
Yeah.
Is natural duty the same work there?
Well, no, it's not doing the same work. So let me explain the difference here. Two separate contrasts that I've got in mind. The natural duty of justice is a natural duty because it's a duty that persons would have prior to and independent of membership in a political community. That is, it's a duty to create a political community, a condition of public right or civil order, with those with whom you regularly interact. Right? So proximate persons with whom you're regularly interacting. Imagine a state of nature, right? Follow Kant here. You've got a state of nature. We're regularly interacting. We're people of high intelligence and manifest goodwill, and yet we're disagreeing over certain sorts of moral matters. We each have an obligation to secure a condition of public right within which we can all be symmetrically governed. You know, and in fact, none of us has a claim to having our own private conception of right vindicated as the public conception. We'll all prefer that, but none of us has any decisive claim, or to put it otherwise, we each have the same claim that our own private conception be made public, and thus none of us have a decisive claim. So there, the natural duty is natural in the sense that it exists prior to and independent of membership in a political community. Now, when I talk about natural human persons, I mean to distinguish natural human persons, you and I, from artificial corporate persons. Okay? Now, I didn't talk about this at all, but on my view, on Rawls's view, on the view of moderate internationalist cosmopolitans, the political community that is well ordered as a publicly rule-governed system of cooperation for mutual advantage within which basic human rights are secured, etc., right? That political community is an artificial person. a corporate person. It possesses direct analogs of the same capacities that make us as natural persons. It has a capacity to form a view about its own good and to act through its institutions towards its own good. It has a capacity and a disposition to subordinate the pursuit of its own good to fair terms of interaction with others. That is, the polity itself acts on its members' natural duty of justice and secures a just foreign policy vis-a-vis others. In fact, it even has a body. The body is composed of the territory that it occupies and the institutional structure. You might think of its mind as in part informed not just by the institutional structure, but by its history, its traditions, its shared understandings of members, and so on. So there we have corporate persons, and one way one might think about the international order is something like just relations between persons at that level, right? So I don't think when we think about justice as a relation between persons, we want to limit ourselves to natural human persons, you and I. There may be persons of all sorts of, not just aliens that we often discuss when we talk about Kant, what if the rationally free alien arrives, but there may be persons that are institutionally brought into existence, and that's the distinction I have in mind there.
Oh, thank you.
Thank you.